Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Welcome to the Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. As always, my name is Saul Gruber from Gruber Trial Consulting, and I'm your host. Today, we have John Fisher from New York. John is the author of books that many lawyers live and breathe by, The Power of a System and the Law Firm of Your Dreams. Phenomenal books that just help us along, give us ideas of how to automate as much as you can in this crazy business of trial law. But today, John is really going to give us some information on his top 10 list of things to do during Voir Dire. And that's going to help everybody who does Voir Dire. And he really gives you some insight on what he's looking for and what he's thinking about. And I think you're really going to enjoy this podcast. So why don't you take a listen? And here's John Fisher. And we are back. This is Saul Gruber, and you're listening to the Jury Thinks What, a podcast by trial lawyers for trial lawyers. And I figured if we're going to do trial lawyers, we might as well bring somebody like John Fisher in out of New York. If you don't know John, then you're doing something wrong, because there's two books that John has written. Well, two books that I have. Are there more books, John?
No, but there's a third book this year. So
okay.
There are two books, yes.
There are two books that I have read that I told John earlier that if I had read The Power of Systems 10 years ago, I'd probably still be practicing and not being a consultant. It was that powerful. And his new book, which he was nice enough to send to me, is the Law Firm of Your Dreams. I read that and again was blown away. You've got to get these books. John, I mean, thank you so much, for coming on, but for writing these books and helping us out, because we're always I feel like sometimes trial lawyers are just in a fog and we're not sure where to turn next.
Well, first of all, Saul, thank you for having me on your show. I really appreciate it. And thank you for your work for trial lawyers, because I found that our profession does not do enough. Plaintiffs' lawyers do not do enough to help and support each other. And it's people like you that reach out to our profession and say, hey, I'm here to help you. I've been through everything. I can walk you through this, and I'm going to ease your anxiety for your next trial. That's invaluable to me. So I'm grateful for your work. And I will give you my personal email address. So if any of your audience would like a free signed copy of my new book, the Law Firm of Your Dreams, I'm happy to send it to them.
Oh, that's great. We will definitely put it out when we put this out to publication, so to speak. But again, we're here on the Jury Thinks What, and John and I, as all trial lawyers, we've had many conversations of probably the most important thing that happens at a trial. And I know what John's going to say already because we talked about it, but I think he would say it even if we didn't talk about it. John, when you have a trial coming up, what is the most important thing you have to get ready for?
Well, there's actually a lot of things that you have to get ready for, but the most important part of a trial is jury selection, because if you get the wrong jurors, you're not going to win no matter what the facts are and no matter how compelling your case is. So, Saul, I was in White Plains trying a kernicterus case. So that's a brain damaged baby case.
Okay.
And I was able, due to little shenanigans with the expert disclosure, I was able to preclude the defendants from producing any expert witnesses in the defense of a pediatrician in a medical malpractice case. I had put in really what I felt was a very strong case. The defense had no experts. I felt like everything was in our favor. The jury got the case. There was no settlement offer on a really strong case.
Where they had no expert.
They had
no settlement offer. Wow.
Yeah. After 4 weeks of trial, the jury goes to deliberate. They come back in about 40 minutes with the defense verdict. And the point of that is that even if all of the evidence goes your way, and even if you're able to preclude any expert witnesses from testifying for the defense, so everything's perfect, you still, if you've got the wrong jury, you will lose the case. So jury selection is the most critical part of a trial. I've always believed that, and I will go to my grave believing that. And it's so important, Saul, in jury selection, not to necessarily get them to be jurors to be impressed by you or even to like you. I don't care if a juror likes me. What I do care is whether they believe what I'm saying. Credibility is everything.
But don't you think sometimes that they go hand in hand a little bit? I mean, if you really come off to be pompous or obnoxious to the jury, they may not listen to anything you say?
Maybe, but look, I've seen plenty of cases where the defense attorneys were obnoxious jerks, and it didn't really matter. And I've had cases where the jurors will come back and say, "Oh, you're such a nice guy," and everything, yet they still find me against me. And so credibility is the key to everything. And for that reason, in jury selection, one of the defense attorneys once told me that what they try to do in every trial is pick a little nugget where they feel that you've exaggerated something, even if it's slightly, and they'll blow it up into a mountain and make it look like this is the worst offense in the world history. And that's what you're combating, because what they're doing with that tactic is they're challenging your credibility. They're saying this guy is not worthy of belief. And so mastering jury selection, if you said to me, we have a trial starting on Monday, what should we focus on first? I'd say, let's focus on jury selection. You and I will block out the afternoon. We're going to spend time focusing on the different intricacies and nuances of jury selection and what we're going to do and how we're going to ask certain questions, because if we screw that up, the rest of the trial doesn't matter.
Right.
So nailing that down is the most important part of a case.
I mean, I can still remember trying a case. I mean, I'm going back to the 80s, so I may be dating myself. And it was a hotly contested case with Allstate, car accident case. The defense attorney was a curmudgeon, just a mean person. And the main defense was my lady was fat. Therefore, any injuries that she had to come from her weight. And the cross-examination on her was brutal, where I thought to myself, well, that I have to win the trial now after that cross-examination. Case went in pretty well. We ended up losing. And speaking to one of the jurors, I said, well, why don't you tell me a little bit about what you were thinking? And she said, well, we hated the defense attorney. We thought he was as mean as could be, and we didn't believe anything he said. And I looked at her and I said, well, but you found in his favor. I said, yeah, and someone noticed he had a wedding band on and said, well, he must not be completely horrible because someone loves him.
Exactly.
I'm like, wow, didn't see that coming.
Every little nuance matters. If you're married, you need to wear a wedding ring, because the jurors are going to look you up online and find out everything that they possibly can about you. Do politics matter? Of course they do. Whether someone is a independent, non-affiliated, Republican, Democrat, politics matters. And Saul, one of the things that I would do is right off the top, like you ask, well, how do you build credibility? Is it just because they like you? No, it's not. That has nothing to do with credibility, in my view. What the quickest and only real way to build credibility is by showing your biggest danger point or vulnerability right off the get-go. So, for example, in a death case, my client I represented the widow of the decedent, was a seatbelted passenger in a truck. He absolutely had nothing to do in terms of causing the wreck. The defendant was a tractor trailer carrier. And what happened is we found out an autopsy revealed that our guy, the decedent, his blood system was full of cocaine in the autopsy. So right to start jury selection, I'm saying, I just want you to know that the autopsy revealed that there was cocaine in his body. We have no explanation. We've got no excuse, and we're not going to come up with one. And I just want you to know it is okay if you say, we think we should go home right now. And I totally understand and I respect any opinion that you express. How do you feel? And then what they would say in response is, well, wait a minute. So he had cocaine. We're not in favor of that. But What's that got to do with the wreck? He didn't contribute to the wreck. He didn't cause it. And so maybe the guy made a mistake. What they were doing, Saul, they were rallying to my defense because I revealed the danger point in the case.
And I guess at that point, you also want to know who's not going to rally to your defense and who's going to say, no, if he's got cocaine in the system.
Perfect.
Yeah.
So let's go there. If they say to you, oh, Saul, look, your client is scum. We hate you and we think you should go to hell. Then you say, you know what you say at that point? You say, thank you very much. And that's not insincere. That's 100% sincere. And the reason I say that is because in jury selection, I want them to open up with their raw feelings. And so if they tell me that they hate my guts, well, that's what I've asked them to do, is to be sincere and genuine. And I would say, let's explore that. Tell me more. The best words you can ever use on jury selection, please tell me more. You want them to share their feelings. Once you've exhausted everything and you say they say, I've got nothing more to say, just keep nodding your head. Your nonverbal communication will get them to keep talking.
Right.
Then when they're finally done, you say, I want to give them a warm chocolate brownie. I say, I want to give this chocolate brownie to you, this warm appreciation, because you did exactly what I asked you to do. You were brutally honest with me. Right. And I want to tell you, that's the reason why this system works, because of people like you. So I want to say thank you. And so once you've given them that praise, other people are like, wait a minute, if I do the same thing, will he praise me too? And so the next question is, who else shares Mr. Jones's feelings about this? And all of a sudden you get them holding their hand up. And then what happens? And this is a true story. I'm in rural New York. I get everyone to say that I'm scum. My client's got a terrible case. They hate me. And the court said, the judge was there. He said, every one of you, you're all excused.
Right. And that's your job in Voir Dire. That's great.
So of 55 prospective jurors in that case, we bounced 52 by a challenge cause through the judge, simply because we were able to get them to open up. Now, if they didn't open up with me, if they didn't say anything negative about the case, I would not have been doing a very good job. Getting them to piss all over my case, that is what gets, I mean, look, we're not going to change their opinions at all.
Exactly right.
During the course of the trial. So all we need to do is find out who's already against us and who has an open mind. And once we find out the ones against us, we got to talk them off. And there are very tried and true methods for doing that. But number one, it's not by being hostile or aggressive. It's by being nice and friendly and getting them to talk and basically piss all over the case. And once they do that, then you're like, great, let's open the floodgates. Let's get everyone talking and let's get the whole crowd of them off this jury.
I mean, I've often said we don't select a jury, we deselect a jury. Mm-hmm. We've got to get the bad people off and then just get the open-minded people on, and we're in much better shape.
Yeah.
Now, I can tell you in New Jersey, at least in state court, it's difficult because we have judge-driven voir dire. Yeah. Where, the judge really is going to be asking questions. And I can guarantee you he's not going to ask it like you just did, John, or he or she. And that's one of the things we always run into in New Jersey as well as federal court, where they give you, 8 minutes to do the voir dire of 15 people, fully anticipating you keeping 12 of those 15 people, no matter what. So, and I know a lot of our audience are younger lawyers and are looking for those tried and true methods, like your David Letterman top 10, so to speak, of what you want to do when you have a limited amount of time in voir dire.
Yeah. So Saul, number one, if let's say that you're the judge and you say, you've got 15 minutes, counselor, take it, leave it, you're done after that. What I would do is, number one, you have to find out in advance of jury selection, what if there's going to be a time limit. You need to ask for a conference with the judge. Tell judge, is there a time frame?
Right.
You have to come armed with the case law. The case law would be, hey, by New York state law, we're entitled to this amount of time. And for example, 2 to 3 hours is the minimum time for jury selection, just the first round in New York state. Wow. They have to give you at least that. But let's just say that the judge is really mean and rotten. what I would do is a few things. I love scaled questions. Scaled questions give you a really good sense of how a juror really feels. And I'll give you a few examples of that. But one thing I also want to do is give the jurors a pass and go home car ticket. And basically what I want them to know, it's totally okay for them if this is not the right case for them. So I will say to them, it is a duty and a privilege to serve on jury, but it's also a duty to not serve on a case that's not appropriate for you. So you have just as much a duty not to serve when it's not the right case for you. So we're giving them a free pass. You want to leave right now, here's your ticket, because if they don't want to be there, we don't want them there. So it's so important to give them that. And you start out with your strongest stuff. This is a very big and important case. Those are the first words out of my mouth. The reason I want this jury to know the first words, this is a huge case. This is not some garden variety case. It's enormous. And the judges, let's say the judge is sitting there and you've got all this time, break out your scaled questions. So scaled questions would be 1 through 10, 10 being you strongly agree, 1 being strongly disagree, and the numbers between would vary. And then you ask scaled questions and you have someone actually writing down the numbers for each one of the jurors. And then you'll get a sense just through their scaled numbers, how they feel. If supported by the evidence, how uncomfortable or comfortable would you feel including millions of dollars in your verdict for pain and suffering and mental anguish?
Right.
0 being very uncomfortable, 10 being very comfortable. And so scaled questions are a really quick and easy way to get to the heart of the matter. You ask them that question.
Now, John, when you go in, because you're going in on mainly personal injury cases, and a lot of those scaled questions, I think, are going to be similar to the ones you did last month, the month before. You go in with some sort of opinion or rule, so to speak, as to what each of those answers would mean and who you want to stay away from.
Yeah, no. So there's an outfit in Fort Lauderdale, right, that would, well, first of all, going back a step, get a demographic profile. All of it's available. Social media stuff. There's an outfit in Fort Lauderdale that I've used where they'll actually give you a profile of all the information of a jury, political party, whether they own a house, all of this. And it's too much information to digest. But if you just get like the 3 to 5 bullet points of that information, it will help you get started. And then basically what you're doing is you're working off those bullet points. If you were injured through the negligence of another person, would you sue? And give me the scaled score. And Saul, they'll often qualify the answer by saying, well, it depends. If it was a really severe injury, then I would. Now that person's leaning on the fence. If you've got a soft tissue neck or back injury, you don't want them on this jury. No. And so, and then once you use your scaled questions, you need to prevent that juror from being rehabilitated by the defense attorney. So 3 simple questions. From what I hear you saying, Saul, is that you have a strongly held conviction that you've held for a long time. Did I hear that? Am I understanding that correct? And then you nod your head as you say that. And then you nod your head and you say, yeah, that's right. Yeah. And what I'm hearing you say, Saul, is that no matter what, all the evidence you hear, and no matter what anyone else says, you will still have this strongly held conviction. Is that fair to say? Then nod your head. They will nod their head in return and they will agree with you. And even if the judge comes out here and gives you instructions to disregard your feelings, what I'm hearing you say is you will not be able to do that. Is that correct? And they'll nod your head as you do it. And then all of a sudden you've prevented that juror from being rehabilitated by the defense attorney, because once the defense attorney gets up, they're going to try to say, wouldn't you be able to keep a fair and open mind in this case? Wouldn't you be able to hear all the evidence? So you have to anticipate the questions that they will use and take it away from them. So say, Judge, the juror has already said that strongly held conviction and the evidence and instructions on the law by the court will not change their conviction. Right. And then you go to the case law and you say, Your Honor, under the CPLR in New York, all we have to show is that the prospective juror is not indifferent between the parties. And clearly they're not indifferent. And so then if the judge says, you're going to have to use a peremptory challenge, then I say, okay, then let's make a record. You have to make a record for appeal, because and then you lay out exactly what you've got.
Sure.
You write in quotes everything that person said, and here's the reasons. And then the judge is going to be like, you know what? Send them home. You've made your case here, because every peremptory challenge is precious, and you don't want to use one unless you absolutely have to. The last case I had, Saul, in Westchester, it was crazy. They took all the Hispanic prospective jurors and just said, if English is not your first language, go home. And I'm like, wait a minute, that's crazy.
Whoa.
Because all we had in that case was all these ultra wealthy people who own multi-million-dollar homes.
Right.
And that person would not have the same life experiences as a blue collar laborer from Peekskill, New York, And so it's like lawyers are bad. These lawsuits are bad. And it's harder in medical malpractice than it is in personal injury.
Much harder.
The bias against medical malpractice claims is so strong throughout the country.
Well, I mean, we want to think that we all have a doctor.
Yeah.
And we have to believe there's got to be some illusion of safety. We have to believe that doctor's doing the right thing and that she's always going to be right. Because if that's not the case, oh my God, when will we sleep?
Exactly. And Saul, that's a great point, because even during COVID, doctors have reached the status of superheroes,
right.
and you need to confront that. And in the COVID era, you'd have to say, look, we really appreciate the sacrifices that physicians have made. Many of them have put their lives in jeopardy to help people, and embrace that. And I am so grateful for that. But there are some who don't necessarily play by the rules of everyone else.
Right.
And, and then get the jurors to speak about their feelings about COVID and how good or bad. Because look, if you don't talk about it, they're going to go back to the deliberation room and say, we think doctors rock. They're the best thing in the world. And that lawyer, another catch-all phrase, Saul, if you say you've got 1 minute, counselor, finish up. I'd say, if you were in my shoes, are you someone that you'd want sitting in this juror? And then you might say, if you were me, is there anything at all that you can think of that I didn't ask, but you think might be relevant to this case? You're trying to get them to open up. If there's a juror who's a can of worms and is sitting there folded, nonverbal communication is everything. In a jury selection, the key is not to act like a lawyer. Treat it like it's a cocktail party. And what that means is, how would you interact with someone at a cocktail party? You'd be informal, you'd be funny, witty, having a good time. There's no reason why you would be lawyerly in a jury selection, because the jurors are going to perceive and make judgments about you. So just let the conversation go.
I've always thought the key to trying cases is to not act lawyerly. I've never understood the lawyers who would ask questions, especially in like a motor vehicle accident. In what direction was your vehicle traveling? I'm like, that's a question I would never ask in my life at any point in time. First of all, I don't even know directions unless I'm going towards the ocean. I know that's east. Short of that, I'm done. And I would always ask something like, well, where are you going? What road are you on? What direction? Where were you headed to? And then let them say I was going to the mall, so that the jurors are all thinking to themselves, oh, you're on Route 38 going to the mall. I got it. I know exactly where you were.
And so just think about this. If you had you got the 5 minutes from the judge, and you want your number to be in front of the jurors as soon as humanly possible.
Right.
You want to have a little big butcher pad right next to you and put the number in there. And then you ask the jurors, if supported by the evidence, how comfortable would you be including $15 million for pain and suffering in your verdict? And then what you say is, they might say not comfortable at all or very comfortable, or they'll qualify everything. You might ask them, some people think the quality of medical care has gone up in the last 10 years. Other people feel the quality of medical care has gone down. Which way do you lean? And trying to get them to talk. Now, the most important skill in jury selection is active listening, which Lisa Blue calls mindfulness. And mindfulness means you're not thinking about the next question that you've got to ask. You're thinking about digesting the answer of the juror and thinking and then responding. The most appropriate way to show respect for a jury is to mimic the last three words that they used. What I'm hearing you say is that only if there was a catastrophic injury would you include $15 million for pain and suffering. Is that right? And so by mimicking the words, mirroring the words that they use,
Sure.
You're showing respect for their answer and that you're listening to them, which is so important.
I love the which way do you lean questions as well as the scaled questions, because they open up a conversation. We do them in the focus groups as well, because I don't want to hear a yes. I mean, the worst thing that can happen when you're selecting a jury is you ask that question and they say yes. That means you screwed up. You did something absolutely horrible there. So right. I love the which way do you lean questions as well.
And just think about it. If you've got a traumatic brain injury, I mean, I never have clients present during jury selection. At most, I might introduce them and then they leave. But I don't want them there in jury selection. I never have them there. And so what I would do, though, is I would get the jury ready in a traumatic brain injury case for our client who looks okay. So my client, Joe, looks fine. How many think that you would not include millions of dollars in your verdict because he looks fine? And they might say that first, they might just say nothing. The goal is simply to get one to open up and then get them to join your tribe. Joining, what you're trying to do once you weed out some of them is getting the others to join your tribe and know that they're part of something that can impact society in a meaningful way. It's ultimately what you want to do is be mindful of the responses that are given, be an active listener. The best advice, Saul, I got, I'm just out of law school. It's my first trial. It's a small motor vehicle case. And I'm there with the senior partner of my firm, and I'm going to do jury selection. And so I stand up and I've got all these copious notes and I'm holding them up like this. I'm sweating all over my body. And so during the first break, the senior partner takes all of my notes, he crumples them up and he throws in the garbage. And he says, go bond with the jury. And he was so right. Just what you want to do is build a connection rapport, and reading off a script of notes is not building a rapport.
I mean, the worst thing you could do is just really even have notes with you.
I agree.
I've always had somebody else taking notes.
No, absolutely. Another strategy, Saul, that you might use as a plaintiff's attorney is to build up the defense. And you might say that you're building up the expectations that they're about to hear the world's greatest lawyer. Joe Smith, the defense lawyer, is the best in the country. Right. What you're doing is you're setting expectations very high for the defense. And then the jury's going to wait a minute. They weren't that great at all. So that's another tactic that I think the second George Bush used. He said, hey, George Bush sucks at debates. And then people heard him and they're like, well, he wasn't that bad, actually. So they lowered expectations for him. And we try to raise expectations for the defense.
Oh, that's interesting. That's pretty smart. I mean, do you use that tactic when you only have 20 to 30 minutes of voir dire, though? Or can you really get into that if you have a very limited amount of voir dire?
Probably not get into that if you have limited voir dire.
Right.
But what I would say during the COVID era, we have so many wonderful healthcare professionals that we owe so much to. But that doesn't mean that there aren't some who have made a mistake and been negligent. What I'd like to know is, what I'd like you to know is this a case for you, yes or no? And basically getting them to admit their feelings about this. And you might give them a free pass. Do you feel concerned enough about COVID that you wouldn't feel comfortable sitting as a juror on this case? Are you uncomfortable wearing a mask all day long? And so giving them the opportunity to say, no, I'm really not comfortable. I don't want to be here. They don't want to be here. We don't want them there. Right.
We did a big series early in the year of online focus groups, and we're continuing them. We're trying to do one. We're tapering them off a little, just to try to find out what people are thinking as to, are they afraid of coming to court? Are they not afraid? And some other biographical questions we can start putting things together. One of the things I'm shocked to learn is people are not, at least in the focus groups we've done, giving doctors and nurses that super aura, superpower aura that I thought they would. They're saying pretty consistently in every different way we're talking to them about it is, well, look, they were always really special people, but it doesn't mean you can't make a mistake. I was taken aback by that. I don't know if you've done any focus groups on that issue since COVID.
No, I haven't. But what I have done, and I think we both share this feeling, is focus groups for $500 are the most valuable use of a plaintiff's attorney's money. Because not that a focus group is going to show you what the outcome of the trial will be, but it will show you the questions that you forgot or you not even on your radar to ask or think about. So what are the questions that a jury wants to answer, but you forgot about? And it's the craziest thing. So Saul, one of my cases was a mother dropped off her kids, 4 kids with a babysitter. The mother ended up going to a Yankees game, and 2 of the kids and the babysitter drowned that day in a public park, right? And the 2 other surviving kids witnessed the drowning deaths. And so I focus grouped this case, and there were all kinds of safety violations. And the focus group jurors were like, that jerk of a mother, she went to a Yankees game while her kids were drowning. We find that she's 100% negligent. I'm like, are you kidding me? That's irrelevant to this case. So I made a motion in limine, and the judge and the defense attorney agreed that the purpose of that trip by the mother is irrelevant. And then I went back to another focus group, and I said, this time the mother dropped off the kids to go see her dying mother in the Bronx. And the jurors were like, oh, what a nice lady. And that babysitter in the park were 100% negligent. It's things that we think are irrelevant matter the most to jurors. I mean, it's crazy.
I couldn't agree with you more. I mean, for clients, we don't even do one focus group. I say, look, we're going to at least do 2. We could do one in the morning, in the afternoon and the evening, and just create all completely different scenarios and see what they say to us, see what they come up with. Because for that reason, the whole case could be about she went to a Yankees game and not about the 14 safety violations where they drowned.
Or Saul, you could say, let's forget about all that stuff. Let's just focus on an accident reconstruction or a simulation of an accident or whatever. And let's have them pick it apart. Like, that's silly. That exhibit is ridiculous.
Absolutely.
That doesn't make any sense. And then what you do is you're tweaking the exhibit or the reconstruction video, and you can say, okay, now we need to fine tune this. This is how a jury is going to pick apart our exhibit. And then you show them different photographs, and you notice that they'll notice things that you never even thought about. So without a doubt, with the money we spend on experts and everything, the $500 on a focus group is the best use of a plaintiff's attorney's money.
Yeah, I tell people it'll cost closer to $1,000, but same difference. It's the same amount. To me, that's the same amount of money you could get, and especially now that we can do it online, it takes away half of the battle. Yeah, I mean, I've suggested it, and I will always suggest that if you're in a personal injury firm or a trial firm like both of us have been in, you should have focus group Fridays. One Friday a month, you just have a focus group. And when somebody would say to me, an associate would say, well, we don't really have anything to focus. I said, really? Because I have your numbers. So you should be making $15 million a year. And since you're not, you have something to focus. You have a deposition coming up. There's always 10 questions that you want to know what somebody thinks about. And that is just incredibly important.
Well, so what we do is, and this is called the Jury Project. It's a special event that we have for other lawyers. We'll do it for a county bar association. But what I'll do is I'll pick another law firm and I'll say, would you have a case that you'd want to do a focus group with me? And they're like, well, what would I want to do that for? But I said, well, let's just see it. We'll put it on for a county bar association. We'll show them in an hour and a half what a focus group is like. Sure. And then we will have the attendees watch jury deliberations in real time. And this has been one of the best marketing tools in my tool shed, because the law firm that I'll do with this, like, hey, that was extraordinarily valuable. I really appreciate that you went to all that trouble to do this for us. And by the way, we might have a couple of cases to talk to you about. And so doing focus groups with other law firms is an extremely valuable way to build relationships that otherwise would not exist.
Yeah. And plus you take the, one of the real keys that I've always had a problem with when we used to do our own focus groups is, we went in with some blinders on. We went in already with, we used to call them litigation blinders, where we thought certain things were not a problem, so we didn't care about them. But if you get somebody who's not in the case already running that focus group, all of a sudden you're going to learn so much, and you could just do it for each other. So it's pretty good stuff.
And the other thing I think, Saul, that attorneys overlook is the idea of a shadow or a ghost juror. So if you're on your first day of a trial, let's say it's jury selection or a key witness, have your assistant bring in 2 or 3 people who don't know you, don't know your law firm, have them sit in the back. And then when the day is over, do a debriefing, have your associate do a debriefing and find out, what do they think? Am I coming across as a jerk? Am I obnoxious? And what you find out is what they think is important is completely different than what you view. And like, for example, if you're a trial attorney and if you're married and you don't have a wedding ring, the jurors are going to look you up online. They're going to say, wait a minute, why doesn't that guy wear a wedding ring? So your clothes are important. And the way that you present is important. I see so many lawyers who looks totally pompous in front of a jury, and I don't think they realize it. But so the most important thing with body posture, be evenly balanced on your feet, put your hands down by your side, not across your chest or in your pockets. And if you want them to open up, spread your arms wide and say, hey, I really appreciate that. Could you share more with us about this? Get them to open up and encourage them. And I bring my arms together like this.
Sure.
Hey, I am so grateful that you shared that with us.
That whole vulnerable feel is when your arms are down by your side and they're kind of open palmed and you're just putting it out there. That's that showing vulnerability, which will definitely have people want to respond to you as opposed to looking at them sternly, or God forbid pointing.
I have to tell you something. If I went in a group of trial lawyers, I'll just say to them, I want you to stand up, close your eyes, and I want you to relax every ounce of your body, beginning with your forehead all the way down to your toes. And I want you to relax, loosen your shoulders, loosen your hips, relax. And then I want you to maintain that pose for just 15 seconds. And then I want you to open your eyes. Now tell me what you observe. And they look around like, I don't know. What do you mean? What you're observing is that their feet are evenly balanced. Their hands are by their sides. And when we are truly comfortable, that is the way that we appear non-verbally. But when we're uncomfortable, what we do is we fold our arms.
Absolutely.
We put our hands in our pockets. We look at the ceiling. We do all this nonsense. And I tell everyone who testifies, you got to make eye contact with the jury, put your hands on your knees, and just don't worry about what you have to say. Just bond with them, tell a joke, laugh, connect with them. Because what we're trying to do is build a bond between you and the jury.
And in today's day and age, and we'll get back to Voir Dire a little bit, but really, this is all applies to Voir Dire. In today's day and age where we all have a phone, may not be an iPhone, maybe it's an Android, but whatever it does, it records. You can buy a selfie stick for $15, put the phone, spread its legs out, and just do your opening, right? Looking at the phone. And then you could tell so many things when you watch it. I don't know why every lawyer doesn't do that for every major part of the trial, including cross-examination, quite frankly, because, although I was always a bit of a pit bull in cross-examination, sometimes it worked, sometimes it didn't work. But if we did it more, if we just looked at a camera and talked the way we really want to talk, it'll really help us when we get in front of the jury.
Well, and Saul, if you don't have a paralegal to write down notes of everything that's said, you can actually transcribe everything using Otter AI. So Otter AI will keep a transcript word for word, so you can go back in your notes. And if you want to try to refresh things, you could go to the judge. We had this transcribed. Here's actually, because in New York, we don't have a court reporter typing everything down in jury selection. But Otter AI, you activate that and you've got a transcript of every word.
Oh, it's the easiest thing in the world. I mean, there's no question about it.
Yeah.
I mean, there's so many things that we have available to us today. We have to be thoughtful enough to use it in the right way, but that's a whole nother podcast. But so now I want to pretend you're in New Jersey and the judge says to you, okay, Mr. Fisher, here are the 15 questions I get to ask. You get 3 open-ended questions. That's all we get in New Jersey. What do you want to ask?
If you were injured through the negligence of another, would you sue? Number one. If they say no, they can't be on the jury.
Got it.
Because that's number one, because they will put themselves in the shoes of your client. And if they're telling you, no, I wouldn't sue, that means it's wrong for your client to sue. That's number one. Other than your faith and your family, what is most important to you? You want to find, aside from faith and family, what is the passion of that person? And let's see, if I had a third one, I think I would go with the number, that number question. If you feel it was supported by the evidence, how uncomfortable or comfortable would you feel including $15 million in your verdict for pain and suffering? That way, you're not only gauging their comfort level with including millions of dollars, you're actually giving them the number. Those would be probably my 3 questions.
Let me back you up. I understand the first question and what you're looking for. The second question, they tell you what their passion is. What are you what are you looking to find? What are you going to do with that answer?
Well, really what we're looking to do is to get them to open up and start talking. Okay. And so an open-ended question is really the goal of that. And what you're trying to find out is what do they do with their free time? Are they, like, for example, David Ball would say, you want people who are charitable on your jury. You want people who are serving other people. You want people who, for example, school teachers, people who are dedicated to service. So what you're trying to find out really is if I were to ask you, who have you made the greatest impact on someone's life? Would it be someone above you or below you? That answer tells me a lot. Are you doing something because you can help get ahead by doing it? Or are you doing something simply by helping someone beneath you? If somebody helps homeless people, that's a caring, compassionate person. And you want caring, compassionate on your jury. Right. I mean, I hate to say this, but overall, women are much more caring and compassionate than men. But in certain cases, and I know this is a generalization, but if analytics and science really matter, we want an engineer, and the majority of engineers are men. They are much more analytical. If you've got an accident reconstruction that shows analytically that the accident was not your client's fault, you want engineers on that case. If you've got $15 million or $25 million in a life care plan, having a CPA might be a good thing because they understand the numbers. So you really want to tailor everything to the specific.
I always shied away from engineers and CPAs because I felt that they would not get sucked into the passion, the feelings and things of that nature. They would be able to put aside any feelings they had and look right directly at an issue and try to solve the problem when we don't want them necessarily to solve that problem.
No, but Saul, they might not be great on damages, but they definitely, if your case requires really a careful analytic eye, they might be the ideal jury because they can see through all the crap and get right to the science and the physics and say, I've got this. And where I'll see other people be like, oh, it doesn't really matter what the science is or the math is. That the defendant seems like such a nice kid, so I'm going to side with him. That's a non-analytical person, and you may not want that person.
So now you're looking at the number, and I know, how do you get to the number that you want to give the jury in voir dire? How do you reach that number?
Well, what you do is you try to build it up as much as you can on economics. So life care plan, loss of earnings, all of that. And then you give them these numbers and you say, look, we have $2.7 million in the life care plan, but that's really just scratching the surface because that sort of just helps them. But what really matters in this case is the impact on the quality of their life. And that is the non-economic harm. And that far exceeds the $2.7 million. And then you give them a number. And I learned this from a trial consultant I work with, Steve Schultz, who I mentioned. Put that number right on a butcher pad, put it in front of the jury and give them the numbers, because what they see visually, they will remember much better than what you tell them verbally.
And I agree with Steve. I mean, I think visually, if you can somehow get them to look at something visually as they're hearing you say it, it has so much more power and means so much more.
Absolutely.
And one of the things we've been doing in focus groups is I don't really like to ask jurors, for a verdict, because we really haven't duplicated what's going to happen at trial.
Right.
So that's meaningless.
Yeah,
What I do is say, is there a number that the plaintiff would suggest that would absolutely offend you? And we talk about it. I say, give me the lowest number that you think you could hear before you get offended. And I think that's really helped some of my clients come up with that number.
I don't like using numbers in focus groups at all. And the reason for they just haven't had all the information that they need to make a decision. Right. And it's sort of like, would an actual juror be as willing to give that number as in a focus group? No, they're not. They're stingy. No. And so I really try to focus on finding those questions that I have not thought of, and then sculpting the case, the trial presentation, so you're answering all the questions that they have. Because the worst feeling in the world is to get done with the trial and have a juror say to you, man, you did not ask this question. The whole trial was waiting for you to ask that question. That's where focus groups come in.
Yeah. I don't know if you know this, but in New Jersey, the rules were amended probably 7 or 8 years ago that will allow jurors to ask questions at the end of each witness, write the questions and give them in to the judge, but both parties have to agree. Now, I obviously always would agree to that.
And Saul, the other thing is, I would agree to that too. The other thing is, I always want jurors, 2 tips here. One thing is, you always want to ask for the jurors to have notepads. The reason for that, when you have a case involving economics and your economist is doling out the numbers, and you see the defense sees the jurors furiously scribbling the numbers on a notepad, that's when you've got them. And that scares the hell out of the defense attorney. The other thing is, we always ask for a pre-trial instruction on the burden of proof, and there is a basis for that, because jurors really do not have preconceived notions about different areas of law, but except for one, the burden of proof. The only thing that they've heard about is beyond a reasonable doubt. And if you don't get that pre-trial instruction on the burden of proof, they're going to go through the whole trial thinking that the plaintiff has to show the proof beyond a reasonable doubt, when we don't. So they're using that as a filter the entire trial that is way beyond what is necessary for preponderance of the evidence in New York. And so trying to get that instruction given to the jury before the trial begins is so critical.
We've done it so many different ways. We've done it in an opening statement where we had 2 equal piles of paper, a ream of paper, and say all the plaintiff has to prove, and take the one piece of paper off. We've tried, and invariably, I swear, I think a lot of cases that are lost are because of what you just said, because the jurors are like, well, maybe it was that way. Yeah, they said it, but it's certainly, I have my own reasonable doubt about it. And you want to say, but that's not the standard. I find that to be a very difficult issue in a civil case. And I've also found that the jurors a lot of times just don't get it.
Yeah, no, they don't get it. But the reality is, we don't want them sitting through a trial thinking beyond a reasonable doubt is the burden that we have to meet. And so we need to give them the instruction. And when the defense attorney says, Your Honor, why wouldn't we just give them all the instructions before the trial? I say, well, because the jurors do not have preconceived notions about all of these different issues, but they do when it comes to beyond a reasonable doubt. And so that's the reason why it's so critically important. And I can't believe in our country that judges and courts are not catching on to this, because it's not fair to the plaintiff and it's not fair to the jurors either.
Most of the judges my clients have appeared in front of, are willing to give that a pre-trial charge. Sometimes maybe they'll give one on experts, they'll give it on witnesses, they'll give it on credibility, and they'll add burden of proof on it. You don't want it to be too much, but and remember, the defense, for all the lawyers out there, the defense is only looking to confuse. They're not looking to prove anything. They're looking to just find, as you said earlier, find that one nugget, which now means everything that comes out of the plaintiff's mouth is false. False in one, false in all.
Put in your case as quick as possible. Get right to the point. with everything you do, direct examination. I want to get to the expert's opinions as quickly as I possibly can. No messing around. The reason for that, all the qualification stuff, who cares? That can come at the end.
I agree.
Seriously.
I absolutely agree.
And that someone went to Harvard or Yale, nobody cares. And so save it to the end, get right into the opinions, get it in front of them, and put it on a butcher pad for the jury to see. 1, 2, 3, here's the opinions.
Have you ever tried to get the opinion of an expert in during Voir Dire? In other words, start right off. Are you prepared to give us an opinion today?
In Voir Dire?
Well, we call it when you're qualifying the expert. In other words, you bring expert, John, the engineer on.
Oh, yeah. Yeah. So certainly as early as you want to get their opinion. If I could get to their opinion, it's the first question that I have, I would do it. I've never had the guts to actually do that, but I would. And
I have done that.
Okay. So you have more gumption than I do.
But there was objections and I didn't really care, to be brutally honest with you, but I wanted that opinion out before we did anything. And I basically said, you're in court today, correct? Yes. And you were hired and you come to court ready to give an opinion? Right. Yes, I am. And what is that opinion? And there's objections, but it didn't matter to me because they got it out and then we dealt with it. So I think it's important.
I totally agree. And the basis for the opinion can come later, but the jury needs to hear before they're silly. If you go through an hour of qualifications, the jury's asleep by that time.
I worked on a case with Tad Thomas not that long ago. Tad got a great verdict. And basically what he said was, I wanted everything to be 15 to 20 minutes. I didn't want anything to be long. It was a nursing home case. And he had witnesses 5, 6, 7 a day waiting. And the trial was only for plaintiffs a day and a half, which is really short for a professional malpractice case. And the verdict was much higher because it was so short. Because as Tad said, he stopped playing around and got to the point, especially in cross-examination. Boom, 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 boom. That's all I have for that guy, as my cousin Vinny says.
No, every trial, there's really no reason why you can't try a case with 5 witnesses, your client, an expert, an economist, maybe 1 or 2 others, and be done with it. Brevity is the key for a plaintiff's attorney. Long trials are the enemy. And the defensive lawyers want to drag everything out forever because once you bore the jury and they start falling asleep, you've lost the case.
No, there's no question. So let me back you up a little bit and go back to Voir Dire for a second. And again, we're with John Fisher, and all you need to do is look at all the books that he's read, and you're going to love them. The Law Firm of Your Dreams, and of course, the Power of a System, and everything he does there goes right to the way he tries cases, as you can hear. But I think that's the way successful trial lawyers handle things. They want to get to it and get to it. So now we've done the 3 questions you ask, and what is the most important thing, other than what we've talked about, you want to find out from that juror in Voir Dire?
The most important thing, really what I'm looking for to find out is if they have any leaning, what I would call a leaning for one side or the other. And if they have a leaning, what I want to do is explore it, find out the strength of the conviction, and then prevent them from being rehabilitated by the defense. So the ultimate goal is to find people who have a leaning for the defense, getting them to dig their grave, locking them into a box, and not letting them escape.
One thing we know that always hurts us, or helps us, depending on which side of the verdict you're on, is trying to determine who is the leader of the jury. How do you go about doing that if you think you can at all?
Well, sure. I think finding the leader of a jury is relatively easy because you're looking for someone who's articulate, well-spoken. How do they interact with other people? Do they sort of guide and organize people? Or are they quiet, looking down at the ground with their arms folded? Just their nonverbal communication alone, before they even sit down, will tell you a lot about who they are. But when they speak, are they articulate? Do they communicate well? All of those things go. And if somebody is quiet and shy, they're not going to be an outspoken advocate for one side or the other.
John, you help lawyers all over the country so much. I see you pop up on our different Facebook groups we're a part of and different things. help me out. Tell me the different things you're doing for lawyers, because I'm astounded at how many things you're doing. And you've got, what do you call it, the jury project?
Jury project, yes. But what we do, the biggest lesson I've learned in my career is surrounding myself with high achieving attorneys who you can learn from, leverage their successes. Incredible people like Seth Price of Price Benowitz in DC, amazing people like Rich Grungo and his partner Bill in Cherry Hill, New Jersey.
From my old stomping grounds.
Yeah, just incredible people. Craig Goldenfarb in West Palm Beach. And just leveraging their knowledge because they're doing things much bigger and better than I am, and just learning from them. So the one piece of advice I'd give to every lawyer starting out or more experienced, join with a mastermind of elite performing attorneys so you can leverage their knowledge and wisdom and learn from them. And it's the best thing I've done. I've done 2 masterminds. One's called the Mastermind Experience. Our next meeting is in Washington, D.C. at Price Benowitz on September 10th. If anyone was interested, go to mastermindexperience.com.
I'll have to ask you that. So now, other than me texting Seth, how else would we join that?
Well, it's application only, but you'd go to mastermindexperience.com. Someone, if you were interested, call my cell, 518-265-9131. If you want a free signed copy of my book, The Law Firm of Your Dreams, email me at jfisher, Fisher, lawyer@gmail.com, and I will be happy to mail you a signed copy. The Mastermind Experience meets September 10th in Washington, D.C., February 18th in the Southern Caribbean island of Curacao. Amazing. Last year we were in a year, I guess before the pandemic, we were in Maui. And then April 8th, we will be joining forces with Craig Goldenfarb's 7-figure lawyer. April 7th is the 7-figure lawyer. April 8th is the Mastermind Experience in New York City. It's going to be awesome. We have special guests. We have amazing people. And it's the thing that has made the biggest difference in my career is joining a mastermind and creating a mastermind.
Well, thank you very much, John. I appreciate you spending some time with us and our audience, and I know everybody enjoyed it. So thanks a lot. I really appreciate it.
So it's been my pleasure, and keep doing what you're doing for our profession, because we need more people like you who are helping trial lawyers improve their practices and get better and alleviate the stress and anxiety of trial, because we all experience that.
Amen.
You're not alone when you have that. And someone like Saul can give you expert advice and guide you because you've been there. You've done all this stuff. You know what it takes to win. And so I appreciate your work for our profession.
Thanks, bud. I'll talk to you soon.
You're welcome. Thanks, Saul.
Thanks. And again, we listened to John Fisher. I have his new book I'm holding up here, The Law Firm of Your Dreams. It's a phenomenal book, and it's one that a lot of people live by. And that was really a great recitation of ideas for voir dire and just for being credible when you're in front of a jury. Some really good information from John that I think we all can use in all of our cases. And again, I am Saul Gruber, host of The Jury Thinks What?, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. And I'm just reminding everybody, John was very nice about saying if you email him, call him, he'll send you a signed book. And that's just incredibly valuable. And think about joining, if not one of John's mastermind programs, but maybe one of Lawyer Mind's mastermind programs or someone's. There's something really cathartic about being able to talk your problems through with someone else who may have a different way of looking at things other than you, especially if you're a sole practitioner in a very small firm. Again, this is Saul Gruber from Gruber Trial Consulting, and thank you for joining us to the Jury Thinks What? On the Lawyer Minds ecosystem.
That concludes another episode of the Jury Thinks What? Podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.